So this assignment is where we're going to start digging into our trial brief, okay? And we're going to, break down again. We're going to talk a little more about conducting legal research for the trial brief, how to construct that persuasive legal argument, and how to outline the brief effectively. And we're going to do this kind of in chunks, so don't worry about that. But remember that the purpose of a trial brief is that it is a persuasive legal document that gets submitted to a trial court, and it's arguing why a judge should rule in favor of a party on a motion before or during a trial. So let's dig in a little bit deeper, though. So why is a trial brief even important? And there's actually a few reasons that we're going to talk about. But first, it helps judges to make decisions. So these briefs are used for motions like a motion to suppress evidence, motions to dismiss, motions for summary judgment, things like that. And in many cases, trials are actually won or lost based on written motions. Okay. So let's say that you have a defense attorney who successfully argues a motion to suppress evidence in a criminal case. The prosecution then can, drop the charges entirely due to a lack of evidence. They can also keep going if they want. Sometimes they're on a mission, but nonetheless, that's just an example. It also frames legal issues early on. Okay, so the trial brief is going to set the stage for arguments that are going to be made during the trial. Okay, it's going to present the facts, the procedural history, the legal issues, and the argument. And it's all going to be done in a structured format. And judges also rely on trial briefs to understand the cases. And that's because judges are extremely busy. And a well-written trial brief is going to allow them to quickly kind of grasp the key legal issues before an actual hearing. Okay. So, and the truth of the matter is you might have a judge who has, say, 10, 15 cases scheduled for the day, and they may only spend, a few minutes on each argument. So the brief has to make an impact before the oral arguments actually begin. This is where it's kind of make or break time. But before we go further, again, I want to pause to talk about our case in State v. Carter. So remember that, again, you don't have to take notes about anything, but this is where we're going to just kind of back up. But remember that Alex is 32. He was arrested in Atlanta after an altercation outside of the bar, and he injured Michael Reynolds, and it was caught on surveillance footage, okay? And it shows Carter striking Reynolds and causing him to fall down, hit his head, and the traumatic brain injury was a result, okay? And let's say we're going to add in that he's in a coma, okay? And Alex was arrested, and he was charged with aggravated assault and reckless conduct. But the facts of the case are the two had never met. Again, witness statements showed that Reynolds was intoxicated and actually had initiated a verbal confrontation between the two inside of the bar. That outside, Reynolds made contact with Carter first by grabbing his arm, and Carter responded by pushing Reynolds away. And that's when, Reynolds stepped forward. He gets struck with a closed fist, and he ends up, getting knocked unconscious. Unfortunately, again, our surveillance footage doesn't show whether it was self-defense or excessive force. But we do have the fact that Carter did stay at the scene. He did call 911. He did cooperate with police, and he was arrested on site. And the other fact is that Reynolds does have a history of aggressive behavior when he's intoxicated. So now let's shift back and talk about conducting research for the trial brief. Now we have to look at what do we even research, okay? And for this particular assignment, you have to research the case laws and statutes, which you're already doing for the other assignment. But it is addressing the following, key issues in this case. So, self-defense is a legal defense in Georgia, distinguishing aggravated assault from simple battery, the admissibility of prior bad acts of the victim, and the legal standards for motions to dismiss or to suppress evidence. Now, where do you even begin to find the legal authority? And again, we're going to use things like Westlaw and LexisNexis. We have LexisNexis, of course, but These are best for finding the binding precedents and court decisions. I find they're easier. Again, we have Google Scholar, which does it's free and it's a case law research tool. And then you have the state court websites, and this is going to give you, the official opinions from the Supreme Court and the Georgia Court of Appeals. Now, you're going to start with the Georgia Criminal Code to find the statutory definitions of self-defense and aggravated assault before searching for the actual case law. Now we need to talk about where do you find the relevant cases. And again, a lot of this overlaps from what I talked about before. But you're going to use the Boolean search techniques to narrow down the results. So again, you're using Westlaw, LexisNexis, whatever. Again, we're going to use self-defense and aggravated assault and Georgia and case law and 2020. And that right there is going to filter the results to only Georgia cases from 2020 onward that discuss the self-defense and aggravated assault cases. And again, if you have no binding precedent that exists, then you're going to look for persuasive authority from similar jurisdictions. You can also look at law review articles, legal treatises, all those things for like background information. But again, we're just going to kind of move through this kind of quickly. But now let's discuss constructing the persuasive legal argument. So let's talk about the role of legal arguments in a trial. And remember that a legal argument is going to explain to the court why they should rule in favor of your client based on an existing law and legal precedent. Okay, so a strong legal argument is going to look like it's going to be structured where it's going to clearly identify the legal issue. It is going to state the applicable rule, whether it's statutes, case law, and or could be both. It is going to apply the rule to the facts of the case, and it's going to draw a logical conclusion. Now, we have to develop the arguments for both sides. Now, for the defense, we are looking for self-defense was justified. And your keywords here are that the self-defense was actually justified. So you want to make sure that you are seeing cases where it was okay to use it because, typically the law does not want people harming other people. But in some cases it says, well, it's okay. And usually that is where you have a situation like Carter, where Carter reasonably feared for his safety when Reynolds grabbed him. And your keywords here are the reasonably feared for his safety. Okay. So again, we're looking for justifiable self-defense based on the reasonable fear for safety, and that the self-defense was proportionate to the threat. And again, the response was proportionate is what it is what you're looking for here. And, from there, you're going to use case law to show the courts how they have ruled in favor of similar self-defense claims. Okay. Now for the prosecution. All right. So for the prosecution, we want to look at Carter's response was not proportionate because one punch caused a severe injury. Now your keywords here that you're going to be looking for are not proportionate and severe injury. Okay. Then you want the surveillance video shows no immediate threat to Carter's safety. And we want to focus on no immediate threat. And then we want to also look at precedent that shows excessive force negates a self-defense claim. And keyword here. And your keyword here is, or your keywords is that precedent shows. So, these are kind of the things you're going to be looking for when it comes to both sides. Now, the structure of the trial brief, your outline should kind of follow this format. So it should start with an introduction. The introduction itself, you have to state the legal issue clearly. And let me stress this, state the legal issue clearly. Okay. Go back to those grammar lessons and, remind yourself, like, is there anything that's ambiguous? Ask yourself the who, the what, all of those things, and make sure you haven't missed a thing. Now, you want to briefly introduce the facts of the case. Again, facts of the case. Leave out anything that's opinion, emotion, things like that. And then we want to explain what ruling we're requesting. Now, an example of this would look like this brief supports the defendant's motion to dismiss the aggravated assault charge on the grounds that Alex Carter acted in lawful self-defense under Georgia law. So again, keep the introduction part, fairly simple. And here's the thing too. You'll find a lot of things that are going to vary in terms of whether or not you should put like more detail, less detail, but we're going to kind of get into that as we continue to go and, learn to craft it and pull it out just a little bit more. Next, we're going to have the statement of facts. And the statement of facts is going to present the facts objectively, but in a way that supports your argument. Now, keyword here, objectively. Okay. So make sure that you are not looking at subjectively, like emotionally. We want to stay on point. Okay. We also want to highlight the key details. And again, highlight the key details. I don't mean like with a highlighter. I mean, you want to hit on those. We want that to be like, who did what? When did they do it? And why does this matter? Okay, let's look at an example. So on March 15th, 2024, the defendant, Alex Carter, was involved in an altercation with Michael Reynolds. Surveillance footage shows Reynolds making physical contact with Carter before Carter struck him in response. Okay, hopefully this is making sense. But again, objectively, stay on point with those facts. Next is the legal argument. Now, the legal argument is going to do two things. It is going to identify the key legal issues, and let me just stress, key legal issues, and it is where you will apply the case law and statutes to each point. Again, case law, okay? Now, what does it look like for each point? Go back to those key legal issues, right? So, first is like whether Carter's use of force was justified under Georgia's self-defense statute. Again, use of force, okay? Whether Carter's response was proportionate to the threat. Again, I'm stressing, was that response proportionate? And whether the prior incidents of Reynolds' aggressive behavior should be admissible. So here, we need to stress Reynolds' aggressive behavior. Example would be under OCGA section 16-3-21, a person is justified in using force when they reasonably believe such force is necessary to protect themselves from imminent bodily harm. Courts have held in State v. Jones 310 JA 285 2022 that a single defensive strike in response to an initial act of aggression is justified self-defense. And finally, we have the conclusion. So the conclusion is going to summarize the argument, and it's going to request relief from the court. Keywords here, request relief. Okay, I can't stress enough. You always have to ask the court for something. Okay, if you don't, you really have no case. It's kind of like going into a restaurant and you want food, but you just don't do anything. You just stand there. You have to ask, you have to order, you have to ask them for what it is that you want. So just, again, be specific on this relief too. Example. For example, for the foregoing reasons, the defendant respectfully requests that this court dismiss a charge of aggravated assault and rule that the defendant acted in lawful self-defense. Okay? So, all right, so your assignment for this week is you're going to take your two cases that you got from your last assignment that you were looking at. And actually, if you didn't do two relevant cases, then you want to make sure that you go back and just kind of pick another one for this particular thing. But we want to have two or more relevant cases. Okay. And so just put in there, like, do a heading that says like cases and put what they are and explain their significance to the actual case. Okay. And then start your trial brief outline. Okay. So I gave you what it's supposed to look like, the structure. And we'll, of course, dig into the pieces a little bit more. But what I want you to do is focus back on the legal arguments. Okay. And I want you to start kind of organizing out what your legal arguments are. And I've given you most of them anyhow. But I kind of want you to start thinking about how you're going to frame it and how you're going to persuade, a judge. Again, you're not writing out like the whole thing at the moment. You're just creating your outline and adding in what your legal arguments are going to be. Don't forget to properly cite your stuff. And if you have any questions, just reach out and ask me. Bye.